Thank you so much for that warm introduction, and thank you to everybody for joining us here today. So I'm just going to kick off this panel and then turn it over to Kathy and Erica to take us away. But the motivation for this panel was drawing on some of the remarks for those of you who are in the room that I made earlier today, talking about some of the ways that courts have been under attack and how courts' public legitimacy has often been under threat. There's an urgent need to build more public support and public understanding about the importance of the courts, the role that the courts should be playing in our democracy so that they can help stave off attacks and be partners to demand more resources and enhanced access to justice within our court system. We have a starting point in many instances where there's very low public information about the courts. People don't know anything about them. They're not activated to think about the importance of the courts, to call on their elected leaders and others to promote judicial independence values. And so what we're going to do here today is talk a little bit with some experienced advocates who have been involved in different ways in building public support for judicial independence values. I'll let them kind of take it away with their presentations, but essentially Kathy is going to lead us off sharing some messaging research that Piper has been involved with about ways of communicating about judicial independence values. And then Erica is going to walk us through an example of a public communications campaign, a public outreach efforts that she has been active in, or her organization, the National Council of Jewish Women of Minnesota, has been engaging with stakeholders within their community as one case study of how this kind of public education and public engagement might work. We're going to have, I'll pose a couple questions with moderator's privilege, and then we'll have some interactive elements throughout the presentations, but then at the end are going to be sure that we leave a lot of time for question and answer. So really encourage folks here as well as people who are participating via Zoom to think about questions, and we really want this to be an engaged discussion. So with that, I'm going to turn it over to Kathy first to get us started. Thank you so much.
Thank you, Alicia. I'll say that this is the first in-person presentation I've been to since the pandemic started. So hopefully I haven't gotten too rusty with my work. But as Alicia said, I am the senior program officer at the Piper Fund. I'm actually based here in Minnesota, but all the staff work remotely from Georgia all the way over to Washington State when it comes to the Piper Fund. We've been doing this research for a number of years. I've been active with this for 9 years, and it's something that a lot of people are not aware of when it comes to the different types of attacks against state courts, and also the different responses and the successful responses that have been occurring in states. Often I've talked about winning is not losing. Winning is not losing the independence of your state court. And often when I report to our funders, we say nothing happened and we worked really hard on making sure that didn't happen. So I'm only going to highlight some of our work when it comes to messaging. It's really fun to do message testing, and if you've never been involved, I thought I would kind of highlight some of the work that we do when it comes to some of the message testing that we have done. We've worked with a firm called Goodwin Simon Strategic Research. They're based on the West Coast. We've done message testing a number of times with them, but generally what happens is we have a focus group. Before the pandemic, we had them in person. After the pandemic, we did them virtually. The reason we do those focus groups is we want to hear from people about how they want to talk about courts and what their concerns are. That builds towards a survey where we then survey people to find out what terms work, what terms don't work, and after kind of creating arguments, do we shift their perceptions on the courts? And I will say, yes, we do. You just have to talk about them and you have to meet people where they are. So the next slide will tell you some information. Like Alicia said, there's really low information when it comes to courts. Unfortunately, when people are asked, what are the three branches of government? The House, the Senate, and the executive branch. Courts are not thought of, and that's the reality. When asked, can you name a state Supreme Court justice? Judge Judy is named because she's the most famous justice, right? And then the other thing too is like, we even hired a cognitive linguist to analyze not what is said, but what is heard. And the cognitive linguist asked us, Is it a court ruling? Is it a court opinion? Is it a court decision? Like what do judges do? And in fact, when it comes to opinion, a couple of years ago, a member of a state legislature said, well, I have my opinion and the court has their opinion. And they were saying that they were equivalent. And that's where some of our fights are, is like to explain that a court opinion is based on a constitution and an analysis of a case where a legislator's opinion is their personal opinion and that they are not equivalent. Now, I thought I'd kind of highlight some of the things that we do when we do message testing. This might look a little confusing, and hopefully I'll have it be understandable for you. But you'll see the top of this is the initial vote. We ask people what they think of these words, and we've done this with a lot of different words. And then later we ask them, after we've talked about the courts and the way they should operate, how warm they feel when it comes to these terms. As it says at the top, 30% is a strong feeling. So 30% is actually either good if you want it to be good or bad if you're really concerned about it. Now, when you look at this, I will just point out that not only do we track it based on the terms, but on race and gender. And so we can find out, well, perhaps white women see equal justice under the law, 32%, again, 30 is good. So that's pretty good for white women, but when you go to API women, it's 16%. So it can differ based on gender or on race, and then there's even, if you look at fair and impartial courts, at the very initial, we're looking at the top part of it. If you look at API women, 30%, API men, 15%. So you can't make an assumption about terms initially. But what's really important is after we talk about the courts and after we talk about how they should operate, we can see that the final vote after a long survey, that perceptions shift within those words and those the language that's used. So the important thing is having conversations and discussing the courts. So again, it's a lot of data right there, but I just want to highlight that there is not one term that works with one population. This next slide is a prep slide for you. We're going to show you a video. Do you know what dial testing is? Have you seen or heard of it? Where you go and, okay, so a dial test is you're sitting in a room and you have a dial or you have a up-down button, and if you like something, you push up. If you don't like it, you push down. And this is all done virtually, and over 1,000 people were part of this specific dial test. We actually had 3 or 4 different subjects that were tested. When you look at this chart, you'll see the middle is 50, then it goes up to 100 and down to 0. The dial test begins at 50, so it's neutral position. And then the different colors are different populations. So the blue band is white men and women. The green band is black men and women. The purple band is API men and women. And the orange band is Hispanic men and women. So in a moment, I'm going to show you a video of this former judge talking about the courts. And you can see how people respond to him. And after that, I'm going to push pause and just ask you if you have any reflections on what you heard. So hopefully this video works.
My name is Fanon Rucker. I have 2 children. I'm a lawyer at the Cochran firm, and I spent almost 13 years as a trial judge presiding over several 100,000 cases every day. So I grew up in Gary, Indiana, in what is commonly referred to as the hood, the cut, ghetto. My parents were very active in the civil rights movement, and they implanted in me to recognize that the world isn't fair, but it will treat everyone fair if they make sure that it does. I handle the types of cases that help to shape people's image of the court system, of whether it was fair. I loved it because it was truly the people's court. And it was the one where most often one of us could appear as a witness, as a defendant, or be there to support a family member or a friend or a coworker. The judicial branch is under threat because of the influence that money has in our elections. At least in Ohio and some other locales, in most other states, judges are elected to their position. The other thing that can and probably should be done to help eliminate it is that there is automatic recusal. That means that those who practice in the courts would either be prohibited from donating money, which can make it more difficult for those who are running, or that those who are then still donating money simply can't practice in front of the judges who they give money to. So let me first say that in a life or a professional life, of trial practice, I appeared in front of a lot of judges before I became one. And the best judges that I saw, and I've reflected on this over the years, the best judges I saw were those whose professional and personal backgrounds reflected a broad array of experiences. And so what can we do? We can be more deliberate about seeking, recruiting individuals whose professional and personal experiences are diverse, are more diverse than linear. But we have to be deliberate about making sure that those who we reach out to and recruit are in fact those individuals who by life experience and professional experience reflect that qualification, reflect the fact that they are in fact highly qualified because they've tried cases and they've been outspoken in the community and they've demonstrated the highest commitment to our ethical principles. Now I'm in a unique position because I've served as a prosecutor, because I've served as a civil rights lawyer, because I've actually been on the plaintiff side of the table and on the defense side of the table in civil cases and represented public officials and municipalities, and then served for 13 years in an unbiased position where it wasn't just aspirational, but it was everyday intentional and deliberate. And so now I think it's important that others look at what we're doing, how we're doing it, and how we can possibly do it much better.
Okay, so that's, like I said, we have done a number of videos where we brought in different people from different backgrounds. And just as a moment, does anyone have any reflections on what they just watched, any surprises, or even any comments that you want to share about the video?
I hate to see my own speech, I can't have that in front of me, it must be very uncomfortable. But the one thing I'm wondering about when I look at this is, have you done one thing I'm wondering about when I look at this, I mean, those differences aren't vast. Have you been doing any statistical analysis to see if you've got an actual significant difference here, or what have you done in a way of analysis of this?
Well, when it comes to the videos, all the videos that we've seen, we do analyze it to see if there's a significant difference, but you'll see that it isn't too different. No one went under that 50. They all approved of what he was saying at different levels, but they were minute differences when it comes to the entire video. Any other questions or comments?
What was the number of participants in this? Were they equally balanced based on diversity? And what was the total number? And what conclusion did you draw from the 75%?
Yeah, so we had a total of 1,000 people, a little over 1,000 people were part of this, and we oversampled anyone that was non-white. So we wanted to really have a significant number so that it isn't just like 10 people who are Black people, but something where we could actually see if there was a significant difference and information on that. Is that all the questions that you had, or was it?
What conclusion did you draw as a consequence? And a follow-up, did you do a presentation at all with a mainstream, a Caucasian judge saying the same thing? I'd be interested in the lines then.
Yeah, so in case the folks online couldn't hear that, because I know the mic didn't get there quite on time, the question is, did we test others other than this Black judge and other mainstream individuals? We did test a number of different people with different backgrounds. So we had a Hispanic woman from Arkansas who was just an advocate. She didn't do anything at all with the courts. We had an international, someone who used to work for the State Department to kind of reflect on the US system of courts versus other systems of courts. And I'm sorry, I know that you asked one more thing. But we do our best to make sure that we're not just, a white judge. We did do a white former state Supreme Court justice. She did well, but he did better across the board. But they had different stories to tell. And I think that's one of the pieces that we want when people talk about their experiences, either advocating for judicial independence, which is what the Hispanic woman in Arkansas did, or being on the bench. They all begin with stories, like why are they there, and what experiences have they had either with the system that they want to reform or with the system that they've been a part of.
Well, I think the variances based on diversity tell a story
Yeah.
that we're not really clearly getting. And that's why I asked about a Caucasian judge, and I would be interested in the variances as it relates to that.
Yeah. What I can lead you towards when it comes to the variances is I failed to mention that we have a messaging guide that you can go online and upload it for free. And we highlight not just him, but other people that we tested as well as terms. So I think I mentioned it at the end of this video or at the end of my section, but the name of our messaging guide is called Justice, Not Politics. And it's on our website. There's actually 2 nonprofits that have that name. So if you Google it, you might find out there's a group down in Iowa that is called Justice Not Politics, and another group in Alaska that's called Justice Not Politics. But we do go deeper into it. And generally, what we've learned is that there's no one person, there's no silver bullet. There's no one identity, whether it's race or background, that works. We have to have a broad spectrum of speakers talk about the need for fair courts for all. I'm going to go on, but those are really good questions. Again, we do have this on our online guide. So I'm going to move on to a new round of testing that we conducted last year, or the year before that, in 2021. We had intended on releasing the guide. But what we realized is that in some states, there were state officials who were not initially following court orders. And then we had polled it to find out, is this just like an outlier that these folks in Tennessee and Montana are not following court orders? Or do people support the idea of not following court orders? And based on our polling, we became very concerned. I had a very bad weekend. My boss was on vacation, and I thought I'm going to let her stay on vacation before I say we have a problem. With the idea that people think it's fine not following court orders. So we decided to do what is called rebuttal testing, and that is how do we make sure that people support following court orders and what messages work. So initially I showed you just short phrases. These are going to be a set of longer phrases to look at and just know. I'm going to ask you, what do you think work best? So be ready to read them critically. So this is a statement, and the question is how to respond. Too often, state court judges let their personal bias or political opinions determine their rulings, rather than relying on the rule of law. In these instances, elected officials, such as the governor or state legislatures, should be able to reject a decision handed down by a state court. So that was what we asked, and there are bills proposed that say state legislatures should be able to overrule a judicial decision. So this is based on some reality. So the question we have is, we tested 3 different responses. I'll read them out loud, and I want you to think, which one do you think worked best? We need fair and independent courts that are free of political influence. Allowing the governor or state legislature to reject a decision handed down by a state court would enable politicians to overrule a judge's decision simply because they didn't like it. So that was one. Second one we tested was, state court judges need the freedom and ability to make appropriate decisions based on the rule of law, even when those decisions might be politically unpopular. Accusing judges of political or personal biases is just an attempt by power-hungry politicians and bureaucrats to undermine the proper role of state courts. And the third one we tested was, one of the judiciary's most important roles in our system of checks and balances is ensuring that elected officials follow the law. If elected officials could pick and choose which court rulings they would or would not follow, they would effectively be above the law. So we tested those 3. I'll give you the results in a second, but anyone, okay, why don't we just do this? Raise your hand if you think the first one did the best. And online, you can put it in the chat. I guess you can raise your hand too online. So the second one, who thinks the second one did the best? Maybe a set of fewer people. And then the third one, who thinks the third one did the best? Okay, so for those who are zooming in, it looks like number 3 is the winner here. And you guys got it. It was the third one. They all did really well. Again, earlier I talked about how 30% is pretty good, but the third one did the best. And again, I call this a rebuttal message when in reality, you want to get ahead of the attack. So these messages should be part of conversations all the time. That way, if someone says anything that says, we don't need to follow this court decision or we should reject this, you want to have that someone else say, well, I heard that doesn't make sense, and here's the reason why. And again, this is in our messaging guide. So we have one more example. State courts should not be trusted to reform themselves. State legislatures, which serve as a check and balance on state courts, are the ones who should have oversight of state courts and implement reforms as needed to ensure the courts are functioning properly and within their authority. So again, I'll just add, we tested more than just these two. There's a handful of them. I just had time for two. So which worked best? Number one, our Constitution establishes a set of checks and balances for a reason. Our democracy is strongest when each branch of government, legislative, executive, and judicial, holds about the same amount of power. Trusting politicians in state legislatures to reform the courts would throw the delicate balance of power out of whack. State courts must remain independent from the two political branches in order to play their proper role in our system of checks and balances. So that's the first one, and these are pretty long. Second one, our state constitutions establish state courts as an independent branch of government that wouldn't be beholden to the same political and financial influence that politicians are. If we allow state legislatures to dictate how the courts should function, we're giving politicians who may be compromised by extremist or special interest control over the courts. And then the final one, the political nature of state legislatures means they are poorly equipped to reform state courts, especially when state legislatures are controlled by extremist lawmakers. Our Constitution established courts as an independent branch of government that would be less influenced by politics and special interest. We already have two branches of government that are dominated by partisan politics. We don't need a third. So we'll do the quick vote. You ready to do it? Yeah, sure. Who thinks the first one did the best? Raise your hand. A pretty strong handful here. Who thought the second one did the best? There's a nice number there. And then the third one. Who thought the third one did the best? Fewer people. Let's see if you guys got it. So again, this one did really well. You'll see the top two did the best, but the final one really performed really poorly. It's 39%, which is okay, but really when you see how strong the first one is, that's the one that you should be using. So again, if you go online, you can see the results of a lot of our message testing that we did, including reforms and support for reforms and how to talk about that. So my final notes are, understand that there's low information about state courts, including how judges are selected and how judges make decisions. Utilize messengers with different backgrounds and life experiences. There's no silver bullet about who does the best. And understand that one frame or message may not work with some audiences. Groups in differing states have focused on fair and impartial courts, justice, not politics. Just a quick note about the fair and impartial courts. Our group in Kansas has really been pushing fair and impartial courts over and over and over again. And a lot of groups are saying that does not work right now when it comes to a message, but because the group in Kansas has been so relentless with this, we actually did a focus group 2 or 3 years ago and asked the people in Kansas, what should you look for in a court? And they said fair and impartial, and we thought, this doesn't just magically come from nowhere, that they were repeating the message that our groups are saying. And the reason why I mention this is that repetition is magic, and getting ahead of the game is really important. So again, we will answer questions towards the end, and I'll move on to Erica.
All right. Hi, everyone. My name is Erica Solomon. I'm the executive director of the Minnesota section of the National Council of Jewish Women. We are our own 501c3 here in Minnesota, although we are part of a national network that's based in DC, and there are 50 sections across the country. So depending on where you live, there is likely at least one section in that state. This is our mission statement here. I won't read it out to you, but in general, we do a lot of work, specifically direct service areas, particularly programs that bring equity to schools and children. We do advocacy work, primarily around reproductive health rights and justice, gun safety, and courts, which I'll talk a lot more about. And then we also do a lot of leadership development for women and women identifying folks. advocacy trainings, community partnerships, and different leadership cohorts. So that's a little bit about the broad scope of the work we do, but I'm gonna dive into the section that we call Courts Matter. And again, Courts Matter is part of our national network's messaging strategy. If you visit courtsmatter.org, you can learn a lot more about them. And this comes directly off of their website, just as sort of their individual mission statement for Courts Matter. Federal judges have the power to influence every aspect of public policy. They make decisions every day about healthcare, reproductive rights, bodily autonomy, voting rights, the environment, law enforcement, LGBTQ+ rights, civil rights, and more. These decisions impact our lives today and the lives of future generations. These judges are appointed for life. It is critical that they are fair, independent, and qualified to protect the most oppressed in our society. I was interested to hear Kathy say that the fair and independent actually has not been testing that effectively. I might have to pass that on. Here in Minnesota, the way that the Courts Matter program shows up is through a coalition we lead called Courts Matter Minnesota. It's made up of a number of groups, including Gender Justice, American Association of University of Minnesota Women, Alliance for Better Minnesota, the League of Women Voters, and others. But it's also been mainly effective for us because the vast majority of our network that's following us in the advocacy, service, leadership development I talked about are actually not engaging in this area of courts. They're engaging in some of the things that the news has a lot of reasons to be really fired up about right now. And I think that this, to be honest, often lands as a less exciting issue for some people. And so it's part of our work to just make sure that people understand the extent to which the courts impact every issue that touches our lives that we care about, and how essential it is that they approach those issues in a nonpartisan way. So this is primarily an education and awareness campaign, but it does also encourage some action, which I will circle back to later on. So this slide just shows some examples of certain social media campaigns and events that we've had that have been effective. And I'm sorry, the size is very small, but you do have these slides on your app. So up here we have one that was posted about exactly a year ago on our Facebook page that was talking about diversity, the importance of diversity on the courts. We're always using our hashtag Courts Matter, so that's another great way to see some of our past content on Facebook and Twitter. And then events. Honestly, things moving to the virtual space kind of helped us in some ways because it's easier to get folks to click on something that's happening on Facebook Live, and it's an interesting panel they can watch in their pajamas from their living room than it often was previous to that to get folks to show up. The other format of event that we've had a lot of luck with is a podcast club. Just because podcasts are really accessible, many people are listening to them every day while they're sitting in traffic. So we featured this series that was programmed by Radiolab called More Perfect, that in each episode did like a really deep dive into a certain Supreme Court case from American history. And so we did this event format similar to a book club. Listen to the podcast, come ready to discuss. And that was really popular for folks. Again, with all of our messaging around Courts Matter, to our folks, we're always trying to focus on bringing attention to the fact that court makeup and actions by these judges really should impact concerned citizens on the issues they care about, especially those that reflect the values of NCJW, advancing quality of life for women, children, and families. So I'm going to tell you a little bit about a specific community event model that we've found really successful, and this is a model that's used nationally through Courts Matter called You Be the Judge. So this is the event description that we would put on a promotional Facebook page or flyer, again reiterating that the courts impact every issue we care about. Judges are appointed to lifetime seats on the bench to interpret law and, for better or worse, decide what it means. In addition, this program has a lot of focus on explaining to the general public how the nominations process works, because a lot of folks outside of Supreme Court hearings they might see on the news may not be paying super close attention to how those proceedings go or should go, or had been going, and how they, as concerned citizens, can speak up about them. So this presentation is really interactive. It does, as you'll see soon, give an overview of the structure of the federal court system and how nominations work. But then the part that is really the best part of this program is that it offers this opportunity for folks to explore a real court case and to act as if they were the judges that needed to decide this, and exploring the relevant law involved. So part of what's so great about this program is that it's really easily adapted by the organization that's hosting it, by the region that you're in, by age group. You could host this for middle schoolers or high schoolers, depending on the court case that you choose and the way that you engage with the audience. And then also we found that this is something that we had primarily done in person, but does also work in a virtual format, so long as you can use breakout rooms. So, I don't know if anybody here is a Shakespeare nerd like me, but I was joking before. My presentation is like a play within a play, because now we come to the slideshow with the slideshow within the slideshow. So I'm going to show you these next clump of slides here. These are exactly the slides that we would share with an audience for one of these You Be the Judge events, so that you can see what individuals would have been experiencing. And I'll say this disclaimer throughout. These slides were made for a presentation that was done in 2018. So if you see certain things that you think, that doesn't sit well, it is likely because, wow, a whole lot can change in less than 5 years. And we'll go into that a little bit more later. So the facilitator would start this presentation by, again, stating that the courts impact so many important issues in our lives, the critical role of the judiciary, and tell the audience that you are going to experience firsthand today just how much courts matter. I'm going to sort of cruise through these next couple of slides because I'm guessing that the audience here is probably a little bit more familiar with this than other folks that don't work in this area or haven't recently taken a high school civics class might be. So the next couple of slides mainly just lay out the system of how the state court system and the US court system differ, and how they're broken down. So you'll see on the next slide here, we have the circuit court map that shows how that's broken down across the state, and again, just defining and linking it to things that people likely would have experienced. Things like saying, the things that are happening on the state court system are things like divorces, child custody, traffic violations, some of those things that we are more likely to have come in contact with, depending on how wild a life you're living. Whereas the federal courts are hearing cases that involve the government, the Constitution, federal laws, defining that difference, and then really underscoring the importance of the fact that, unlike state court judges, federal judges are serving in lifetime seats, so that this is an issue that is not necessarily just the next 2 years, the next 4 years. When somebody is in that position, they could be there for 40 years plus. So again, I'm going to cruise through these next couple that are just diving a little deeper on the structure of the court system. But then I'm going to stop at this one because I think this is interesting. Who can see the blue wedge on this pie chart? Anyone bring a magnifying glass? So what this shows is, people pay attention to Supreme Court cases. They make headlines, they make news, they make history. But what this shows us is that the cases taken up by the Supreme Court represent approximately 1/10 of 1% of all federal court cases. And the other large portion of them, 90%, are heard at the district court trial level and 10% at the circuit court. So again, just reminding people that they may have their attention paid to the things that have the widest spread impact on the whole nation. But when you think about the actual number of cases that are being reviewed, it's a tiny, tiny fraction. Okay, so now we come to the interactive portion of the event, and I'm going to ask you all to do a little bit of exploration with me, again, pretending that you are the individuals that have shown up for this event. So, What would happen at this point in the program is that folks would break into tables, and each table would become a panel of judges that has a table captain elected as their chief justice. So I'm going to try to remember now how to get to the other doc I want to get to. Nope. Oh no. Oh, I know, I have to quit the slide first. This is also, I'll say, these handouts are also in your conference app under this session. So this is something that the table captain would get, and it lists the case at the top. Now again, this is one of the things that's so fun about this event, is that it can really be customized depending on what type of case you'd like to focus on, what matters to your audience. I picked a little bit of a spicy meatball for us today. This is a 2011 case, Texas medical providers performing abortion services versus Lakey. So this is a document that table captain would get saying, hey, congrats, you and your group are federal judges now. You are going to guide your fellow judges through a conversation of this court and the major legal question involved, and you're going to come to a conclusion and be prepared to present that. And then this doc here that the table captain gets also presents a couple of guiding questions that I will pull back up in a moment. At this point, I need to scroll down now, not side to side. At this point, everyone would receive a document like this that outlines the facts of the case. Certain things that are key to capture here are the people involved. In this case, Governor Rick Perry. Again, this is from 2011. The Center for Reproductive Rights and Metropolitan OBGYN of San Antonio, and then these three state officials, David Lakey, who gave the case its name. And then to draw out what some of the key questions that were being answered were. So in this particular case, it was revolving around the constitutionality of House Bill 15, which would require, prior to an abortion, a physician had to perform an ultrasound exam and show and explain the real-time images to a pregnant person 24 to 72 hours before the procedure. Physicians were also mandated to play the sound of the fetal heartbeat and get confirmation in writing that the patient had received the required information. So the folks that were bringing this said that this language was clear and unclear and contradictory and unconstitutionally vague, which could lead physicians to unwittingly violate the law, and also argued that the law violated First Amendment free speech rights of doctors and pregnant patients because it forced patients and their doctors to engage in politically motivated discussions. In addition, the explanation of the ultrasound was not information necessary. Forcing doctors to provide this information violated their right to speak freely with the interests of their patients and not the state in mind. So again, the folks at their tables would get this briefing and review it together. There's one section here, which is that the quest of the court was to have a preliminary injunction placed on HB 15, which was argued by the other side was a violation of the 14th Amendment's due process clause. That the bill was, and that's why they argued for the injunction. And then it cited other cases, including Roe v. Wade and Planned Parenthood versus Casey. Then you'll see that in addition to just giving all of this paragraph form description of the case in question, this handout also calls out the very specific passages of relevant law that were considered here. And then the key legal question of the case, which was, in light of all the facts, does House Bill 15 violate the rights of physicians and pregnant people under the US Constitution? So I'm going to bring us back up to these questions to guide deliberations. Do you think the explanations and procedures required under House Bill 15 create substantial obstacles in the path of a woman seeking an abortion? Are all of the requirements of HB 15 relevant to medical decision-making? Could any of the information doctors are required to convey under the bill be misleading or incorrect? Is House Bill 15 vague and or confusing? And the most important question, in light of all the facts, does House Bill 15 violate the rights of physicians and pregnant patients under the US Constitution? So if this were a real event, we would have much time, probably a good 20 or 30 minutes for tables to discuss, to come to some level of consensus on what their answer to this question is, and present to the group. I am going to give you 3 minutes to turn to the other folks in your row and to whatever level you're comfortable, again, reminding you that you are federal judges and you are to be informed not by your personal feelings and beliefs on this matter, but rather the relevant laws that are being cited here. Can you, as a group, answer this fundamental question? Go. Everyone loves impromptu discussion. Sorry, I'll cruise through the rest of this. Okay, gavel, 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 gavel. We really should have had some. Gavel, gavel, gavel. All right, I'm sure that in that hearty 3 minutes, you had some great discussion. Is there anybody that's brave enough to share if you were able to come to a decision, a ruling, or one that you were leaning toward? It's okay if you don't want to share. Oh, I saw a quick hand.
We're taking it under advisement.
Okay,
Thank you.
permissible. This is permissible. Come on, I gave you such an easy question to think about. So again, in an actual event, would be the bulk of the program, and the table captains would be really the leaders of their group to walk through these questions, to come to a decision, and to collect any dissenting viewpoints. And at that point, everyone would come back together, just like I just asked you. There would be a bit of a presentation from each group about what decision they came to and what they based that decision on primarily. At that point, the actual outcome would be revealed. So I won't go into this in too much detail because, again, this was in 2011, which especially in Texas was a bazillion years ago when it comes to talking about reproductive access. But this is what the decision was. It was essentially that the district court judge, whose name is here somewhere, Sam Sparks, granted the request for the preliminary injunction, finding that portions of HB 15 were unconstitutionally vague, and it compelled physicians and patients to engage in government-mandated speech and expression in violation of the First Amendment. The court mainly rejected the Texas defendants' arguments, which mainly relied on the Supreme Court Planned Parenthood of Southeast Pennsylvania versus Casey decision, and found that HB 15 does not compel physicians to apprise women of the risks inherent in abortion, inform the women of available alternatives, and facilitate access to additional information if the women wish to review it before making their decisions. Existing Texas law already compels such speech by physicians in conformity with Casey. Instead, House Bill 15 compels physicians to advance an ideological agenda with which they may not agree, regardless of any medical necessity, and irrespective of whether the pregnant person wishes to listen. These factual differences persuade the court that Casey does not foreclose plaintiff's First Amendment challenge, and so the district court decided to sever provisions from HB 15 and forbade the state from enforcing the law. But of course, and I won't go back to it because it'll take too long, as we saw in the little flow chart of court cases, seldom is that the end of the road. So this case was appealed the following year in the Fifth Circuit, where 3 judges of the Fifth Circuit unanimously agreed to reverse the district court decision and vacated the district court's injunction, thus permitting HB 15 to go into effect. They determined the plaintiffs didn't show they met the 4 requirements in order to get a preliminary injunction. So again, I just want to say, for imagining the audience that would be receiving this, you'll notice that there are some terms here that may not necessarily be terms that folks are very familiar with, and that's, again, intentional. Especially when we get down here to see the final conclusions of the panel of judges. We see terms like, we vacate the district court's injunction, remand for further proceedings. So that's why it's important that the person that's facilitating this conversation has a working knowledge of what these terms mean and how this process goes so that they can help be a resource, because again, the point of this exercise is learning. And then there's a little bit of what happened next, which again was where things stood as of the end of 2012, beginning of 2012. So I'm going to bring us back to the actual presentation now. Uh-oh. Please hold. While I'm advancing to the slide I want to advance to, does anyone have any thoughts, feelings, things that they think might have been helpful or not helpful or scary during that exercise if you were someone coming to this event to learn about courts for the first time? Okay.
I'm curious what other cases you have done.
Yes, thank you. Good question. So again, I think that what is really a great element of this particular model is that you can choose a case that is you can choose a case that involves issues or topics that a group you might work with care particularly about. So again, this was one because NCJW does a lot of work around reproductive rights. Another one that we do a lot of, and I'm sorry, I don't remember the exact case, but it was one from, I believe, 2018 that involved actually very similar to one that the Supreme Court is hearing this year, that involved a high school football coach leading the group in prayer and whether or not that was constitutional. So again, we're National Council of Jewish Women, and because of that element of our identity, we engage a lot in conversations about religious freedoms. Those are 2 that I know we use a lot, but really there is no limit to which case you want to explore. The main thing is that you lay out a description of it and what sort of the key questions and relevant law were. And then, of course, tell people what actually happened, because I think it's really no fun if you spend this time pretending that you're doing this and then you don't get to find out what happened in reality. Okay. Oh, yes.
Hello. Can you hear me?
Yes.
I was just processing this, and I think what is interesting of what this illustrates is just how complicated and exhausting the court process is.
Yeah.
And I think, we've been talking a lot today about engaging the public and getting their trust. But I think this is a really good example of why people disengage and how systems of power benefit from people being tired. So I'm still sitting with that thought, but I think that did a good job of illustrating that. It's just very confusing, and it goes on, and you can't keep up anymore. And what does that mean? And
Yeah, no, I think that's a really great point. And I think, I didn't design this model myself, so I can't speak to the intentionality of it. But what I think that it helps with is, again, to your point about how exhaustive it can be, how many considerations are involved, points to the fact that these judges are filling a really challenging and important role that you might think, oh, someone can just sit up there with a gavel like I see on TV. But really, these folks are being asked to really take deep dives into constitutional law. And again, to speak to some of what Kathy's presentation shared, to really take partisanship out of it, because it's so hard, if you're talking about an issue like abortion that people have very strong, deeply held and deeply seated beliefs in, to have to put yourself in the shoes of someone that is looking only at what the law says and not at what their personal beliefs are, or what lobby group is knocking on their door, or what the governor thinks, is challenging. And I think that just underscores, again, how important it is to have people in these roles that really have earned them. Perfect. So again, at this point in the presentation, we'd circle back to, again, underscoring the importance of these judges, and then taking a little bit of a peek into how these folks get elected to get placed on the bench. So this slide, which is kind of a fun interactive, walks through the process. Home senators send names to the White House. The president makes their nomination. The Senate Judiciary Committee has a hearing and a vote. The full Senate debates and has a vote. And then the judge is confirmed, yay! So again, this is very much a slide showing how the process is supposed to go. Something here that we talk about a lot that I think is terminology or something that people aren't as familiar with are blue slips. So blue slips state that essentially some of this section has to happen, where the home state senators are consulted when the president is making these initial nominations, and has to check off on their permission slip whether or not they feel good about this moving forward. And as you'll see in some futures, the next slide, there have certainly been times where that has not been the case. So again, I want to place these slides in time. These were from an event in 2018, and it was just drawing attention to the fact that during that time period, during the Trump administration, certain things in the process were not really being honored. It was causing things to break down. There often weren't blue slips. The hearings were often really, really stacked. That continues to be a norm, where several nominees were having their hearings in one session, and so there wasn't as much time to really hear from them. And just that, yes, there were several places in the process that weren't followed or are potentially not followed, and because of that, it was really slowing down the process. So I will say I updated this slide. These numbers show us vacancies and pending nominees as of last week. But by comparison, when this slideshow was created in 2018, at the time there were 151 federal vacancies and 60 nominees that were pending. And then the last part of this, which for NCJW's work is kind of the most essential, is just the call to action. I think a lot of people think, great, I learned all this stuff. What do I do about it? What is my role? And we really just draw people's attention in so much of our work is around empowering people as advocates by reminding them that their representatives work for them. Their representatives are there to hear from constituents on what matters to them. So making sure that people understand the importance of letting their senators know their feelings about how these nominations happen, who gets elected in these situations, or who gets nominated, and that we count on them to move the process along as it's supposed to go. And then again, there are some additional action steps that folks are encouraged to take if they want to take a step even beyond. They or their organization can become part of the Courts Matter Minnesota Coalition. They can choose to bring the workshop into one of their communities. We do this a lot in like faith-based groups, school groups. People can contact their senators, sign up for action alerts, submitting an op-ed or letter to the editor. And then again, just connecting this issue to existing work, because a number of the organizations that are involved with the Courts Matter Coalition are not organizations that really directly work with the judiciary or the courts at all. They're organizations that are issue-based, they're grassroots, they're organizing organizations. So again, just elevating this message that courts matter, judges matter, and we should all be empowered to speak up about the importance of who sits on the bench. So that is the Courts Matter program and the You Be the Judge program model in particular. Hope you enjoyed seeing the show within the show. I thank you all for participating in some discussion around a tough issue. And I'm gonna say that we're gonna hold off on further questions until the end.
Yes, so I might pose one first question and then would invite folks in the audience and on Zoom to think about questions you may have, and we can open it up. The first question would be one, and I'm going to help answer this question as well, moderator taking over, but would be curious to hear about some other examples that you've seen. You know, Kathy, you've worked in this fair course space for close to a decade, of other examples of, and you know, from your experience as well, Erica, of other ways that different stakeholders, be they courts, be they judges, advocates, other stakeholders, have been successfully communicating around judicial independence values as we're sort of thinking about different models of how to do this work.
I'll begin. I have my mic on. I think that there's been a number of different unique things that are done by states. In some states, this is possible. In others, I know it isn't. But for example, Iowa, the state Supreme Court going on the road and hearing cases within the communities that really are impacted by those communities. You know, that it could be in a high school and the students could go in and hear what that's like. It decreases the mystery of what happens. It increases people's understanding of how cases are heard and how judges operate. And then when those hearings are over, now I know that they did this before the pandemic. I don't know if they're still doing it. The justices would wander around and answer questions. And I think that's a great way of informing people of how the courts operate, and also humanizing the judges themselves to see that they do have a job, but they also are human. In other places, like I said earlier, it is a mix of different people coming together, where you might have panels or small discussions, where you might have a former judge. Often it's former judges that we speak to rather than sitting judges, because we know that sitting judges might not be at liberty to speak as much as they want to, or even they might even restrain themselves just because they want to be careful about who they're talking to. So bringing in former judges, as well as people that have stood in front of the judge, to kind of talk about their experiences with understanding how courts should operate. But I think an important element is how some courts need to be reformed. So not to say that they're perfect, but that there needs to be a system that is improved.
Yeah, and I'll piggyback on both of those. I think I was just talking about this, how we're relatively fortunate here in the Twin Cities that our capital is just a hop, skip, and a jump down 94 away. And I think our organization does a lot of work bringing people to talk to their representatives and to talk to their senators. But even though it's great to make people familiar with visiting the Capitol, they may not have had opportunities to see the courts at work. So we've had events that have been like rallies or outdoor speakers that are like a circle the courthouse model, where we'll invite people to go to the Minnesota court that's right next to the Capitol and see the work happening in process, and to like be right there where it's happening. Just to leverage your location, which I know isn't an option for everybody, but can be. And then the second thing that I was going to say, I lost my train of thought about. What was the second thing you said? Because it was a jumping off point that I was going to use.
Was it about members of the community and not former judges?
No.
I'll begin by saying, yeah, reform?
Reform,
Yeah.
that was it. Thank you. Thank you. That's the word, yeah. The other thing I'll say is, while Courts Matter is a program that is built around raising awareness around the federal judiciary, I would also, a direction I would like to see us do more work is here at the state level, because we do so much work around getting out the vote and making sure people are showing up and voting for candidates they believe in. Here in Minnesota on election day, you turn over the ballot and it's a whole list of incumbents and people that are running unopposed. And I will just be transparent and share that I usually just bubble them all in because they're running unopposed and I want to say that I voted. And it wasn't until this year that I stopped and thought, I could be bubbling in a bubble for somebody that really does not align with some of these values that I hold closely. And so for all of the candidate forums you see around House and Senate and governor and attorney general, we really as an organization and as a broader community, I think, could be doing more awareness building and conversation about who those judges are that you're seeing on the other side of the ballot. So that's something I'd like to see us raise awareness about moving forward.
That's great. And that's a segue into the one example that I wanted to raise, which is a really interesting initiative by the National Association of Women Judges. They have an Informed Voters Project. So that's an association made up of both sitting and retired judges from federal and state courts, and recognizing that 38 states judges face elections as part of the judicial selection process. That committee essentially identified a real concern that you have very low voter information about judges and very low understanding of what are the appropriate and inappropriate criteria to even be assessing around judicial selection. I showed in my remarks earlier, some of these, negative campaign tactics, people, a judge being attacked not for the reasoning and the way that they actually applied the law, but, a caricature of the outcome of a case, basically ways in which judges' records were being kind of presented in a misleading way. And one challenge that this committee highlighted is that, to a large extent, people haven't thought a lot about courts, the role that they're supposed to play in our democracy, the role judicial elections are supposed to play. And like I said, what are kind of appropriate criteria to be thinking about when you're choosing judges, and what are things that are actually crossing a line or, putting political preferences above judges that are enforcing the law. And so they've developed an entire public education campaign. I'm going to show just a short video, which is, they actually have a longer version of this. This is the short version of it. And they also have a lot of other really interesting public education material. So I think we put links in this PowerPoint as well, so it should be accessible. But is, I think, another really interesting example, and an example of ways that judges have been taking the lead in this public education context and doing things like speakers bureaus, presentations, and the like.
Americans look to their courts for fairness because they trust the judge will handle their case with an even hand, free from the influence of politics and partisanship. When a judge gives every person the same treatment, our courts are what they have always been and must always be: fair and free.
America's courts are fair. Help keep them that way with an informed vote.
So I think, and I'll mention too that I think something that they were at least exploring, I don't know if this actually came to pass, was thinking about things like jury service as opportunities to use those moments where you have people coming together as opportunities for public education, not just around the specifics of what jurors are doing, but really stepping back and doing more around public education about the role of the courts, kind of taking advantage of that captive audience. So I think there's a lot of really creative, interesting ways to think about how different stakeholders within our system can play a role in encouraging this kind of public education. So I can pose more questions, but want to make sure we leave some time for the audience. So I'll pause here and see if we have either in the audience or over Zoom any questions.
There is one question in the chat. Eric, I think it goes back to your presentation. From Martin, I'm curious to know if that example presentation explained, explained how these districts and circuit courts looked at the same case law in theory and reached seemingly 100% opposite decisions.
Whew, what a question. Can you read it one more time, please?
I can. If it explained how these districts and circuit courts looked at the same case law in theory and reached seemingly 100% opposite decisions.
That is a very good question. I think that now that I came to this slide, I want to go back to one. I think that if anything, that speaks to what one of our participants brought up, which is just how nuanced the process is. But I want to quickly zoom back. I do think that that is one of the intentions of showing this circuit court map, especially, the case that we were talking about was the 5th district and pointing out this is Texas, Louisiana, and Mississippi. I know that the other case I mentioned around religious freedom was from Florida and pointing out that that is the 11th circuit, Florida, Alabama, and Georgia. So I think, that's a good opportunity to point to how easily partisanship can inform these if we aren't careful, because I think that we all know what colors we would see on some of these states on the map if we were looking at election returns. So I don't know the answer to that in depth, because I think somebody could write an entire thesis about that very question that someone was posing in a Zoom chat somewhere. But again, I think speaking to the nuance, speaking to the importance of a nonpartisan approach, and speaking to the importance of being a voice, regardless of which of these states you sit in, for the people that are representing you.
Other questions? Well, I'll pose another one while folks think. I think one thread that's kind of come through these presentations is that there's a goal of educating the public around the courts and building support for judicial independence values. It's also the case that for many people, particularly communities of color and other marginalized communities, their experiences of the courts have often not been positive. And so I'd be curious to hear your reflections about how that reality informs the work that you do and how you sort of think about communicating about judicial independence values.
I'll say that, as I mentioned earlier, I've been doing this for 9 years, and we often talk about judicial independence. But the question is, what is the appropriate way to discipline a judge who does not behave in an ethical manner? Who are on judicial discipline boards, and how do those operate? That's been a question that I think that I need to ponder more and be active on, because we do want to have separation of powers. We do want to have fair courts. But when I first started this work, the theory was, well, if there's a bad judge, they can be voted off the bench. That's not what you should do. You should have a strong judicial ethics and discipline board, and people should be informed of how to file a complaint and how to follow that complaint. And so we're slowly increasing that, because we don't want a bad judge to be on a bench, especially in places where someone runs against that judge and doesn't win. If they're a really good attorney, they might not feel like they'll be able to have a fair day in court, because the judge might hold a personal grudge. So I think that that is something that we need to really dig into and explore. The way we've been doing that, again, just as an initial process, is there's an increasing number of court watch programs that are happening, and we're asking them, can you tell us about the complaint process and how you file it, and the process there. But my biggest thing is I want to make sure it's a fair process, and not that if a judge is following the rules that he, she, or they are following, how do we make sure that that they are not attacked for that, and how so it's kind of informing people of how judges should behave, and informing people of how to file a complaint against an unethical judge.
And I would add to that, when you hopefully are in relation with this person that you're potentially talking to, knowing what matters to them, knowing what touches their lives, and finding a way to share with them a story that this has had a positive impact on somebody that looks like them or feels like them. One example I was talking about, because again, NCJW does a lot of work around reproductive health rights and justice, was a case that was brought here in Minnesota this past summer about certain restrictions that were placed around patients seeking abortion care, many similar ones that we saw in the Lakey case we looked at. And those, the outcome was that judge ruled these restrictions that had been on the books for 50 years as unconstitutional. And because of that, they aren't being enforced right now, and it's given leeway to legislators at the Capitol that are working to codify those restrictions being struck down. So I think, again, if I'm talking to somebody and I know that they care deeply about reproductive freedom, and I can say, look at this example of a way that a court case, a judge made this decision that is making change in an issue you care about, that is now helping make even more permanent change at the Capitol.
I don't have a question, but I do have a comment. And first of all, I just wanted to thank you all for your presentation. But my comment is, I'm representing a tribal court system. And so while there are some parallels with the presentation today, it's very different to try, in my mind, I have to convert all this information into, how it would apply in a tribal court situation and representing our own tribal communities. So I just wanted to offer that to you in your presentation, so it's not all state courts. So
thank you. I really appreciate that, and honestly, I will admit that I myself am woefully uninformed about how the tribal court system works. So I hope that you might give a presentation on that soon. Yeah, especially here in Minnesota in the upper Midwest. I think that's really important.
Sorry for what will be a bit of a bomb with 4 minutes ago, but what do you do about a Supreme Court that has no code of ethics?
I'll let Kathy answer that.
Yeah, this is something that we have been working on. It isn't just the U.S. Supreme Court, but other courts, making sure that they have strong and appropriate ethical standards. All I can say is that my hope is that there are movements within states, and there are some states that it appears as if it might be advancing, and there's different ways of doing that, and building towards a national movement. And I know that there is a national movement to improve those, but I think that, I don't know if I explained this to you, but Erica and I are the non-attorneys on this panel. And I think that that's one of the things that we see as a strength, is that regular people should be able to talk about the courts. But Alicia might be able to answer your question better than us.
Well, I'll just say really briefly that, I think it's ridiculous that the Supreme Court doesn't have a code of conduct. I do think that that is itself a public education opportunity because the Supreme Court is so high profile. I think when you see things where, overwhelmingly the public thinks that the Supreme Court should have a code of conduct and is shocked when they learn that they don't, that can create an opportunity to talk more generally about judicial ethics and, broaden the scope to then talk about other issues that might be happening in your state or your community around judicial ethics issues. So, in the spirit of not wasting a crisis, right, when you see something that's a problem in a high profile court that's going where there's an opportunity to really draw attention to that, it can also be an opportunity for a broader conversation and connect things to, work in the states.
I think that when you talk about a code of conduct for the Supreme Court or for any court, we have to go beyond the verbiage and talk about implementation and their compliance. And I think that we write these things down and then we don't move forward insisting on compliance. So when you see that as a solution, I'm not so sure that it is unless you have people strong enough to execute and implement.
I think that's really well put. I agree.
One more question? Sure.
In Under the Wire, we'll do the one more question or comment.
Oh, it was more of a question of implementation is one thing, enforceability, I think, is another issue.
Absolutely, and I'll say that that's something that's come up in the context of the U.S. Supreme Court where, there's the question of having a code of conduct, but then there's also a question of what kinds of judicial discipline opportunities are available. And it would be very challenging to create kind of a robust, enforceable judicial discipline mechanism for the Supreme Court for various constitutional and other reasons. That isn't necessarily the case in state courts, where in many states you have, you do have more robust judicial discipline regimes than the U.S. Supreme Court has, but in many instances, perhaps not enough and without sufficient transparency and public accountability. So with that, I think we're at time. So just wanted to thank our panelists so much and thank everyone in the audience for joining us here today and on Zoom.